Assalamualaikum and hello everyone. I am Siti Asha binti Mak Said would like to present to you about the case review of Muhammad alias Ibrahim versus RHB Bank and another. In the case of Muhammad alias Ibrahim, the level of court is High Court Kuala Lumpur. Who are the parties involved in these cases? There are three parties, which is the plaintiff Muhammad alias Ibrahim, Defendant 1 RHB Bank, and Defendant 2 is another. Next, I continue with the fact of case. The plaintiff alias Ibrahim had sought to construct a bungalow house on a piece of land. For the purpose, had applied for and obtained several Islamic banking facilities from the first defendant, which is RHB Bank. On 8 March 2005, the rights and liabilities of the first defendant in respect of the facilities were vested in the second defendant, which is another. Then, misunderstanding arose between the plaintiff and defendants in respect of the facilities, which is when the bungalow house was found to be unfit for occupation. Then the suit was filed by the plaintiff to declare the facility agreement void and no effect, and also the defendant applied unsuccessfully to strike out the plaintiff's claim. During the striking out application, certain Sharia issues had arisen which needed a reference to the Sharia Advisory Council pursuant to Section 56 and 57 of Central Bank of Malaysia Act 2009. Plaintiffs entertained that the said Section 56 and 57 were ultra-vires the federal institution and seeking to declare as invalid. Do you know what is the issues arise regarding the case of Muhammad alias versus RHB Bank? The issue is regarding the house financing, which is by Bithaman Ajil. The first issue is whether Central Bank of Malaysia Act ultra-vires. Second, whether Sharia Advisory Council has power to decide. Third, whether court bound to follow Sharia Advisory Council. Next, what is the principle laid down by the court of this case? The civil court has the jurisdiction to the sole purpose of establishing here Islamic banking cases. The practice of civil court referring question on Islamic authorities is not something new but has been decided in many previous cases, which is case of Bank Kerjasama Rakyat versus MC Corporate and also Afin Bank Berhad versus Zulkifli Abdullah. Sharia Advisory Council is to create a specialized committee in the fields of Islamic bank in terms of ascertain speedily financial matters, not to perform judicial or quasi-judicial function, and lastly, not an attempt by the executive to take over the judicial power traditionally exercised by the court. So, what is the decision of the court? As a result, the plaintiff is not entitled to the declaration which he seeks. This case is now to be sent to Deputy Registrar for Case Management on 11 May 2011. Since this is the first time the court is dealing with new Section 56 and 57 of Central Bank of Malaysia Act 2009, there is no order as to cause.